Now, our speakers today, I've deliberately, when you do present at a seminar like this, I always find in the minute or two before you get up to present, that's when you start getting a few butterflies in your tummy. You sit there and you think, gee, it's about to happen. I hope I can get my words out fine. Because I know these are experienced speakers, I want to give them the thrill of it, at least one of them, of having that 5 times over. So I haven't told them the order in which they're speaking. We like to keep them on our toes. So here we go. Our first speaker is Ken Schurgott. Ken is a partner at SBN Lawyers. Ken's love of all things tax knows no boundaries. He's the man who recites section 160 ZZZNA in his sleep. He's rumoured to have proposed to his wife by lodging a federal court application with his mother-in-law. His kids have to lodge tax objections to get increases in their pocket money. He's presented more seminars for the Tax Institute than the Tax Institute has even held seminars. Give the man a microphone and a lectern, he's like a pig in mud. Please welcome Ken Schurgott.
Thanks, Lachlan. What you should have said is actually supposed to be Arlene McDonald here. I got told 2 days ago by Lachlan I was going to be the new Arlene McDonald, and I have to speak particularly fast. My topic is Henschke's case. Now, why am I speaking and not Arlene? Well, first of all, she's not here. Secondly, it's my great love of red wine. Thirdly, it's the fact that I'm a South Australian with a German surname, as was the case in Henschke's. I think everyone here has some background appreciation concerning Henschke's. They're great winemakers, and I'm sure the High Court appreciated that, just that the High Court didn't actually favour Henschke's in this matter. This was an appeal from the Supreme Court of South Australia, the full court decision. I'll get on to that in one moment. But what the High Court said in Henschke's case was this. It concerned a deed of retirement of Mrs. Henschke Sr. from a partnership of Henschke & Co. I won't go into the details of that. Simply that she retired from the partnership and she executed a document, amongst others, a deed of retirement. That deed of retirement was a schedule to a sale and asset purchase agreement which had been formulated. At the base, there was $35 million worth of value in the partnership. Mrs. Henschke received a cheque for $5 million odd. And the question was whether this document was in fact a conveyance on sale under Section 60 of the Stamp Duties Act of South Australia. Indeed, was it an instrument by which any estate or interest in property vests in any person? Interest in the legislation included an in-kind equitable interest. And what the High Court said was that Mrs. Henschke's interest in the partnership was such a thing, that following Everett and other decisions, too many of them in the time available to me to mention, it was quite clear that that's what it was, and that she received $5 million, and that effectively what happened when the document was entered into was that the assets of the dissolved partnership passed to the new partnership. And the real principle in that case is the High Court confirming what we've all suspected for a long time, that every time there is a change in personnel or even interests perhaps in a partnership, that it's a new partnership. What the High Court was doing was looking at the South Australian Supreme Court decision. What I have to say about the High Court decision, it's typically cryptic. Even when you read the useful transcript, you find that the High Court goes from one extreme to the other. But what they were reviewing was in fact the decision of the Supreme Court of South Australia, a perfectly well-reasoned decision, as clear as anything, substituted by the cryptic words of the High Court, where the South Australian Supreme Court said the interest ceased and was satisfied. And that was the end of the matter, really, notwithstanding the fact it was documented. It wasn't dealing with the underlying assets, and therefore what it was not an instrument which was a conveyance on sale, therefore not dutiable. Now, what Lachlan asked Arlene to do was to say, well, what's the relevance of this to other matters? My view is not much. It was quite exciting and revolutionary when it was a decision of the South Australian Supreme Court, in that it was a new take on how partnerships really worked. The High Court has gone back to basic principles. It doesn't have a great deal of relevance in my view, simply because each and every bit of state legislation has its own little regime concerning stamp duty in relation to partnerships. In South Australia, they're still back in the dark ages of stamping documents, with some exceptions. In New South Wales, we have dutiable property, including a partnership interest where the partnership has dutiable property. So you look at that and you look to see whether it's a transfer of dutiable property. There's no necessity for an instrument. In Queensland, there's a whole separate provision, the partnership acquisition provisions, which is a regime and rule and code in itself. I think the decision has very little to do with that.